have any of you here had the chance to read Saurabh's new book? Okay, well, I'm hoping that all of you will pick up a copy by the end of this session. At least that's our aim. Now, the book is about equality, and what we are going to try and unpack over the next 40-odd minutes is what that term really means in the way that it was framed in the Constitution, and what its practical manifestations have been over the last few decades for us. So I'm going to start with something very fundamental, Saurabh. Could you just begin with reading out Article 14 and telling us where it came from, what it had its roots in? Perhaps, one of the things that one can think of is the 14th Amendment of the American Constitution, but what else it had its roots in?
As a lawyer, I should remember provisions, but we're also people who deal with specificities, and you have to be very exact with your words. So I'm not going to take a risk and miss out. So let me just read it out to you. And then I'll say something about just Article 14. So the article is one of the shortest in the Constitution in terms of fundamental rights. Our other rights are more lengthily cast. But I suppose because the idea of equality is supposed to be simple, the language is fairly simple. So the article says, the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. Now, this is, as I said, a very pithy little article, which within it contains deep disputes and divides. You mentioned the 14th Amendment. That's something that the American Constitution also promised, equal protection of the laws to people. It's from the 14th Amendment that our language of our Constitution has come. And there is some discussion, and people say that our Constitution is a patchwork of different words from different constitutions. And I think Article 14 is one example of it. But Article 14 is not the only place where the ideal of equality resides within the Constitution. Of course, it's spread through the entire text as an ideal. But specifically, there's something known as Equality Code, which is Articles 14, of course, then 15, 16, and 17 as well. So 3 more articles. One deals with Article 15 with a specific kind of discrimination on the basis of sex, sexuality, gender, and caste, and matters of employment. Then Article 16, which deals also with education and employment. And 17, possibly the most important, is the abolition of untouchability. And because really, we often forget, and I know we're going to discuss the role of caste, but Article 17 possibly was the favorite article maybe of Dr. Ambedkar, and it probably is at his insistence that it found its way as an article which is self-applicable. We can discuss that.
So, it feels intuitive. Equality is, is an ideal that, it feels intuitive to aspire to. But if you really think about it, it's one of the many frameworks through which you could try and imagine a world that we want to live in, the world as it should be. So why equality? Is this a good framework for us to approach the issue of justice and rights and creating a society which has space for as diverse a population as we have?
The preamble of our Constitution, and I was at a session yesterday, and one of the discussions was we should not fetishize the Constitution. I am firmly of the opinion that yes, we must fetishize the Constitution. We must hold it as a holy text, of which the most important part is the preamble, which talks not just of equality. It talks about liberty, it talks about justice, and it talks about fraternity. And it says that through equality, justice, fraternity, and liberty, we will achieve the unity and integrity of India. Because the belief is, and our constitution makers were probably right, that you cannot have a free India, an independent India, a strong India without rights. And these rights have multiple pillars, each of which are interconnected. So I wouldn't say equality is an ideal which stands in distinction from liberty or freedom or justice. In fact, very idea of justice is inherent in the idea of equality. To be in an unequal world would be an unjust world. And if you're an unequal world, then there will be some people who will be at so much at the bottom that they will not be able to exercise any right that they wish. So how are they free? How does liberty apply to them? The idea is the dignity and the autonomy of an individual, of an Indian citizen, relies on a whole host of rights, each of which will come into play at different points of time. There was a time in our jurisprudence in the early 50s when courts believed that they were all separate. But over the years, as humanity develops and the idea of dignity develops, the rubric of equality cannot be seen as divorced from the other rights. And I'd say in a country like India, I don't want to say any one right has priority over others, because every right must be fulfilled. But with such immense inequalities of wealth on the basis of caste, on the basis of gender, sex, sexuality, till you achieve a basic modicum of equality, you are going to have a very unstable social fabric. So if any right is going to ensure the unity and integrity of India, I'd say equality would be pretty much up there.
But, it sounds deceptively simple, the idea of equality. But what does it really mean in a country where we are impossibly diverse as a people, and where we want to hold on to our diversity, where we want to hold on to our individuality as people, as communities? What role does equality play in mediating our coexistence in such a society? And more importantly, did the framers of the Constitution really understand its expanse as an idea? Because when we look at the First Amendment, they seem to be quite frantically trying to struggle with the Pandora's box that equality opens up.
Yes, I think the framers of the Constitution were at the end of it also and did become politicians. And they did what politicians think like, which is you make vast promises as they do in election times. When it comes to its actual application, that's when they want to back off. They want to promise people rights, but when those rights start interfering with their idea of what rights should be, that's when they have a problem. So there were these beautiful discussions in the Constituent Assembly about equality and freedom for the most oppressed castes. That was a big thing, of course, with Dr. Ambedkar as well. And as you rightly pointed out in the First Amendment, the Supreme Court struck down the reservation system. And when faced with that idea that there will be no reservations, the Constitution was promptly amended in 1952, even before the first election to the parliament had happened. So the Constituent Assembly, which gave you those rights, immediately took the rights back because the practice of equality was something that they didn't even imagine could have happened. The same thing had happened, actually, interestingly, on matters of land acquisition. So Article 31 of the Constitution said that there will be compensation paid when your land is acquired. The moment the court started actually ruling in favor of landlords, saying you can't acquire this, or in case of Article 19 on freedom of speech, when a judge in the Punjab High Court struck down the sedition law, and the government thought that now I'm going to lose my control over the citizen, that's when the Constitution was amended immediately. And that's what's been happening for the last 75 years of our Constitution. That the moment that pesky rights come in the way of people, the Constitution is amended, and it's been historic. So your first point was, what is the idea of equality? What does it do? I think the idea of equality really is like a cocoon, which protects the exact diversity you were talking of. I am a queer man, I'm a gay man. I do not want to be treated exactly the same as a straight person because I'm different. A woman can't be treated exactly the same as a man because there are differences. And therefore, these are these diversities and differences we have. The idea of equality protects you that just because you are different, the state will not treat you differently. Rejoice in your differences, rejoice in your diversity, live your life that you wish to, and the state will come to your aid and say, yes, you can be different, you can live your life fully, as differently as you want, without any fear. So I think the idea of equality protects almost your diversity. That's what it is. It's not about sameness. It's about difference and protecting that difference.
So, if perhaps caste, religion, and gender are three key parameters along which we can analyze the import of Article 14 and the Equality Code on the whole, perhaps arguably, safeguards against discrimination on the basis of caste is the most fleshed out in our Constitution. Two parts to this question. One is, why do you think that is? Is it only because of Ambedkar's role in the Constituent Assembly, or are there other factors? And the second part of it is, when we talk about safeguards with regards to caste, the first thing that comes to mind is reservations, which started out obviously as an exception to equality, just in terms of conceptually, right? That obviously one is saying that if you are from a certain caste, there will be a special reservation for you, which in principle goes against the idea of equality, because we are not treating two individuals equally. So it's saying, well, there's a historic disadvantage. We first level the playing field, and then, we can carry on as equals. So it started as an exception, but it has come to be a sort of mainstay in terms of our own understanding of the equality provision. So how do you see that journey?
Well, the problem of caste in India is something that bores audiences in literature festivals, because most people who come here live with the privilege of caste. And for them, it's something so irrelevant. I don't know why we're talking about caste, even though intellectually every one of you is aware that India is a caste-ridden society. You have to drive around the streets of any city or small town in India when you leave the bigger cities, or even in the bigger cities, you leave your big bungalows and go out to the back streets of where you live. Caste defines every aspect of your existence in India. And it's amazing, for something which is so pernicious, so deep, so descriptive about your reality, people like to ignore it. And I suppose one reason people like to ignore that topic about caste is because most people take advantage of their caste privilege. Equality, as I say often, is about dividing a pie into slices. The most caste powerful are happy with the system as it is, because they've got the biggest slice of the pie. So they're never going to be interested in giving the lowest caste, the most oppressed castes, their fair share. But at least when the Constituent Assembly was talking, it was not just Ambedkar. This was a time of idealistic fervor. This was a time when the politicians were possibly rooted more deeply and had their ears to what the life in the country was. It was a desperately poor country at that point of time. I'm not sure, even though we've raised 400 million people out of poverty allegedly, how much better we are. We're still a poor country. But the issue of caste was front and center, not just because of Dr. Ambedkar, but because of a large number of people in the Constituent Assembly who were Dalit, and also the moral authority of the Mahatma, who had made the issue of caste. Of course, they had running this dialogue with the Ambedkar on the issue of caste, and I'm sure that people in the audience will know better about it. But caste was a very important feature, because it was seen as one way of leveling up India. And you couldn't truly level up India till you annihilated caste, or you removed the caste-based inequalities. And that's why we came to the idea of reservations. And you're right, innately, on the face of it, reservations are contrary to the ideal of equality, because if everyone's meant to be treated as equal, why do you have certain reservations? And this is something which I think we spoke about in another session yesterday. Treating two people who are unequally placed by saying you are now equal is the greatest insult to the idea of equality. To tell a woman who is being oppressed and being unable to go to school, who gets no money for her education, who is supposed to go and fetch water for 3 hours and therefore cannot study, to compete for an exam for a medical seat that the son of a rich industrialist or a bureaucrat sits for, and say you're both equal, you can both take this exam, is actually the insult. As long as people are not equal in life, to treat them equally in access to jobs and education is a perpetuation of the inequality. And if you think of equality deeply, and the idea is, and then we start discussing equality of what? Is it equality of opportunity, equality of outcomes? Is it some kind of a formal idea of equality, or is it a substantive idea of equality? But whatever it may be, I think intuitively all of us will feel that the disadvantaged do need a leg up. And the only way the Constitution thought of at that point of time was through the idea of reservations. Reservations both in, after the First Amendment, in education as well as in employment. But perhaps most revolutionary idea was reservation in parliamentary seats. I think we all bemoan the fact, oh, reservations were meant to be only for 10 years, and it's now carried on and will carry on now. But we still remain a deeply unequal country. And the idea was to transfer political power to the oppressed castes, not only because they would then rule and give pass laws in favor of the oppressed castes, but also would act as role models. And your member of parliament would be a person who would inspire you and move people up the social ladder. Because the problem of caste is not just about money. You can get people from caste in second or third generations who've got reservations in the past. They'll get their money, but they will not really move up the social ladder. They will still be treated by their brethren or the people around them as children of a lesser god. So I'm one of those people who doesn't favor the creamy layer system, to exclude the rich from the benefits of reservations, because reservations have not uplifted you in society. So that's what the role of reservations is. But the problem is, there is a certain amount of intellectual laziness and politics that comes in with reservation, that our people and our politicians who are supposed to represent us have just stopped at reservations. It becomes a political issue every 5 years or every 3 years, depending on elections, when you waive your copies of the Constitution and everyone fights about reservation and the idea of equality. But the hard work that is required to be done through investment in education to ensure that the Dalit child gets a proper education, that there is greater economic empowerment in private sector, none of that is happening. So that's why reservations have become this punching bag, because so many are fighting for such few things out there.
No, of course, it can't exist in a vacuum. I mean, there's education, there's also job creation. If we don't have enough jobs for our people, then we are left grappling with how many seats can you reserve and how many people can you ensure equality to via reservation. Perhaps we'll come back to that, but I want to move on to another parameter of, looking at equality, which is gender. What did women get other than the vote? Was there any cognizance of other genders? And could rights based on gender be substantive, be comprehensive without talking of sexuality?
Well, to your last question, no. But that could just be because I'm biased and I see sexuality in everything, but it does exist. Because fighting discrimination on the basis of gender and sexuality is fighting the same thing. It's fighting a patriarchal mindset that is completely inbuilt in most Indian men. from the time they're born, when their mothers tell them you're the best thing that ever happened, we live in this patriarchal society. And these power structures which oppress because it gives power to people as oppressors to oppress others, works against women. It also works against people of a gender minority or sexuality. That's simply how power typically works. Once you start oppressing one lot of people, you just find it's easy to oppress everybody else. That's the mindset of the oppressor. How did the constitution makers think of the role of women? Well, there is a fair bit of history, and there were 15 founding mothers in the Constituent Assembly as well. Typically a small token, the way there is tokenism that still exists on panels in litfests and in boards of companies. But it was still an important token. At least it was there in the imagination of the Constituent Assembly that women exist. And giving a right to vote was not a small thing. It was, at that time, a revolutionary idea. The idea of equality of vote to everybody. Because prior to that, only about 10% of the country had a vote. Because it was based on the fact that you had to be a man, or even if you're a woman, you had to be a landed person. And women didn't have property, so women were automatically excluded. So it was a very powerful, enabling way that women were sought to be given equality. And Article 15 specifically prohibits discrimination on the basis of sex. So that was a promise given to women. There were no reservations, however, for women in either jobs or in education. We've now sought to remedy that by providing for 1/3 reservation in panchayats, which is working well. We've promised that to women in parliament through the amendment of the constitution, based on the census, which I don't think will ever happen. It doesn't seem to be happening. But in 1950, I think while even women were on the radar, the queer community was completely excluded. They weren't thought about. They didn't exist. The Criminal Tribes Act had recently been repealed. Everyone was happy with Section 377 because across the world, it was still the love that could not speak its name. I don't think any member of the Constituent Assembly really wanted to decriminalize homosexuality. They didn't want, possibly, they didn't even think about it. I mean, it's only recently, in the last 10 years, that we queer people have come out of the closet and people are talking about us and we're fighting for our rights. The politicians are still pussyfooting around it. They're still not talking about the rights of the queer community. Why do you think these men in 1950 would talk about it? They didn't. We were out of the radar then, we're out of the radar pretty much even now. And that's why the courts have stepped in and to some extent helped us by saying gender and sex. Those patriarchal power structures which oppress women also oppress people of different genders and different sexualities. And have recognized sexuality as part of sex. So the Constitution didn't, what is the Constitution? The Constitution is not just the words that are written in that text which we flash around. It's also the judgments of the courts. It's also the ideals in that Constitution, the unwritten text, the ethos of the Constitution. And I hope we've moved on to that place now, that even if it was not there in 1950, the Constitution as a living document has started including us queer people within the rubric of sex.
You know, Saurabh, I wonder, law and morality, are peas in a pod in many ways. And both tend to be the reflection of civilizational ethos and tradition in a way, right? Now, our constitution, when it comes about, it recognizes that women are human beings and that something needs to be done to try, and even if they don't go the distance in the way that they do with caste. But when we look at our own traditions, right, the constitution goes against the grain. Like you said, giving the right to vote to women was a revolutionary act at a time when women were throwing themselves in front of horses in England to try and get the right to vote. We have the right to vote as women from the word go. But, in our traditional societies, on the one hand, we go on about how other genders were never pariahs in traditional Indian society. We will talk about Khwaja Sarais, we will talk about this, that, and the other. So where did this blindness come from? Could it be argued that the constitution makers were looking at frameworks of rights, looking at the West, too much for the framework of rights they were setting up, or is there something else that leads to this blindness? Is it immediate historical circumstances?
I know this is a very popular topic nowadays, the Indic civilization and the idea that somehow rights are contrary to the Hindu structure and alien to it, and therefore maybe we can find something which is really truly Indian. But I'll try to point out the stuff that is really truly Indian is fairly discriminatory. It's fairly truly Indian to be a casteist who practices untouchability. It's fairly truly Indian to be a person who discriminates against women because you had laws which discriminated against women. So I think it's important for us to remember that when the Constitution comes, there is a distinct transformative move away from the idea of this morality that was inherited by us. Law and morality are two sides of a coin, fine. But the only morality the Constitution speaks of is constitutional morality. Because the morality of the common masses is often very, very oppressive. It is very famously said by Dr. Ambedkar that he never wanted the village to be strengthened and Panchayati Raj to come in because he found that was the place where the greatest discrimination was acted. It was a den of oppression, is what he said. So this is the morality that India lived in. And the constitution makers had a modern vision based on the innate humanity of people. We may be Indians, but before that we are human beings. And we are born on this planet with certain inherent rights. And till we recognize those inherent rights and seek to give fruition and closure to them, how can you talk about any morality? Every morality must give way ultimately to my rights as a citizen and as a human being. So in a battle between morality and the Constitution, there's not even a contest.
Absolutely. And I think it's intellectually extremely dishonest to point to contradictions, because India is a land of contradictions. You will find an exception to anything that you state as the truth, and to point to those exceptions to try and talk about how we really live in and fare in this society is very dishonest intellectually. So I'm glad you pointed that out, but that naturally opens the door for us to talk about religion. And the Constitution is being framed in the context of a very bloody partition. The biggest battle, the biggest fault line in that moment is that of religion, particularly, Hindus and Muslims. Gandhiji has been assassinated. This is sort of the backdrop. In this context, how do the framers of the Constitution deal with the religion and minorities question? What is given to them, what is not given to them? For example, we know that caste is not really acknowledged when it comes to minorities, when we know that it's as present in their daily life and reality as it is for the majority. It's not acknowledged. There are some concessions given, but then there is also this anxiety to, not to be seen to be pandering to the minorities in this backdrop. So just the historical context would be very helpful. What do you make of what was given to the minorities? And in the wake of what is going on today, but even before our immediate context, when we look at the Sachar Committee report in 2006, which points to the fact that minorities in most cases are faring as badly as lower castes and outcasts in our country, in some cases even worse. How does the constitutional promise of equality hold up?
Well, the time of the framing of the Constitution was also a time of partition, where an unbearable wound was cast on the soul of India. There were demands made effectively of the Muslim community to stand up and prove their loyalty by being the ideal citizen. And that a certain construction of the identity of the Muslim person was demanded at that point of time, expected at that point, and volunteered also by the Muslims of that point of time. Because they wanted to show that yes, we are Indian as you are. So even though prior to the constitution, there were reservations based on religion but not caste in terms of elections. That was because of the Pune Pact, when Mahatma Gandhi famously went on a fast in Yerabada jail to stop reservations on the basis of caste, but the religious minorities had reservations, effectively, the double electorate system. When it comes to the constitution, this is just quietly dropped. When you read the debates and you read the committee that was drafting the constitution, you don't know when it just kind of disappears without much protest with the Muslim members of the constitution, possibly because they wanted to prove their allegiance to the nascent Indian state. And I can understand why people were thinking like that, because there was hope that I may not need reservations. Instead, I will get a protection and a guarantee of protection of secularism in the country. By offering a neutrality of the state, a separation of church and state, are offering the ideal of equality also. You are saying the state will treat everyone equally, and you can do within your domains whatever you wish. So the idea of equality then moves away, and that's where the personal and the political comes in. Whereas for caste, equality is a very political ideal, and you have reservations in A, B, C place. When it comes to equality for religion, and it typically becomes personal. So you're allowed to have your personal domains where the state will not interfere. How much you discriminate within those personal spheres, the state is not concerned with, but the state is neutral to you in terms of your religion, which was possibly necessary at that point of time, but it's still necessary is something we can discuss.
So I want to now come to the fact that, over the last decade or some, intersectionality is a concept that has taken root, at least in certain quarters, and it's a very helpful prism for us to understand how, how to approach the idea of equality. Quite simply put, when we can't think of gender and caste and sexuality and religion in silos, is what intersectionality tells us. But what is still not discussed often enough is that a lot of times these rights can be in conflict. Women's rights can sometimes be in conflict with the rights of queer people. The rights of religious minorities can be in conflict with gender rights. How has the Constitution and its interpretation negotiated with this problem?
You see, rights will always conflict. My right to extend my hand stops by your noses. And the Constitution has left this determination of balancing of rights to the judiciary. The judges are supposed to decide as to how to balance the various rights. So, for instance, you gave the example of how queer rights and women's rights can conflict. It comes as a shock to feminists that sometimes you have to be an anti-LGBT rights person because, for instance, in the marriage equality case that was being argued, we said you must read each provision of the Special Marriage Act in a gender-neutral manner so as to allow men and women, or two men, or any two people of the same gender to get married. But the immediate consequence of that would be that the special protections that are given to women because of their position in society would then be undone. So now there's a conflict between the special rights that a woman needs in a country like India with the demands of the queer community which say that all genders must be treated equally and treat us the same. Same thing with religion and women's rights. As I said earlier, that there is this cocoon of personal law within which the court says we will not touch, and there is equality of religion and we will not interfere. But within that, there is discrimination that can often happen. It happens in every religion. I mean, we like to beat one particular religion, but it's not as though Hinduism is much better. I mean, I was seeing the other day, Uttarakhand is now famous for its civil code, but equally, much before the civil code, a man who inherits agricultural land in Uttarakhand, there is no his sister, if she's married, cannot inherit. So while in Hindu law, you automatically assume that it's now gender neutral, inheritance laws have become gender neutral after 2005, that's not so for agricultural land in Uttarakhand. Now in a state which is so agrarian, to have that discrimination is pretty much a shocker, and we're still living with it and no one talks about it. Right? We like to beat the Muslims about how they discriminate against women, but we don't peer into our own backyard. So there are these fights between different claims of gender, caste, sex, sexuality. And it is ultimately for the court to determine. And the courts realize you can't make everyone happy. You can't please everyone all the time. And that's not the role of the courts as well. But I suppose they tried their best at any point of time. And I suppose some kind of a Rawlsian idea must be applied, which is that you balance the rights in a way that the most marginalized are the ones who get the biggest slice of the pie. You referred to the Sachar Committee report earlier. And then we had a former Prime Minister of our country who said that the poor, the weakest, have the first claim on resources to our country. A statement for which he was ridiculed, which frankly, of course, embodies the ethos of who we are and who we should aspire to be as people. Give to the weakest. But it's apparently a controversial statement.
I'm going to pick up on a couple of things you just said. First, marriage equality for the LGBTQI plus community. What are the implications, Saurabh, of this being denied by the courts?
Well, there are two straight implications. One is the practical one, that I simply don't have the rights that I need to live with my partner on a day-to-day basis. I've been in a relationship with my husband now for 23 years. But if I open a joint account with him and I transfer money in there, will it be taxed in his hands? Because there's gift tax between two strangers that doesn't exist between families. Will he get a visa to stay on in India if he retires? What happens if one of us is ill and I have to take a decision of a medical nature? No hospital will ever recognize that. Rights of straight people within marriage are just such an obvious thing to them that they don't even realize how difficult it is for two queer people to live together without those rights. Society makes it hard enough for us to live together. Our families make it hard enough for us to live together as a queer couple. But when the law makes it impossible to live together by not giving those rights, it's as though you're just tearing people away. And where is the humanity in that, I ask myself. So that's the practical aspect, that I don't get those rights that straight people take for granted. But possibly the most important is a moral aspect as to the state and the government and the constitution and the courts of the day saying that you are not worthy. I will allow two straight people to get married, but you queers, you stand outside the gate. You can look at the building, but you can't come in. That which is good enough for everybody else is not good enough for you. You can't have that. So what does that say about us as people? Are we not worthy? Are we not citizens of this country? Why do I deserve any less? And yet that's what the state demands of me, to accept my second-class status. And that's something I will not do.
I want to now pick up on the cocoon, you mentioning the cocoon of family law, and how we like to beat upon one particular community when it comes to discrimination of women. We've been debating the UCC from the time the Constitution comes into force. But in the way we now approach UCC, by and large, is a sort of envy of the minority community. Why should he be allowed to have two wives if I can't? Why should he be allowed to get away with saying talaq, talaq when I can't, when I have to go to the courts to leave my wife? Now, I wonder, Gandhi gave us a very strong idea that means matter as much as the end, right? Through his struggle and his life and his own body in many ways. In this case, UCC might be a good end, but the means and the ideas that are driving it do they matter as much? Or if the end gives us a more equal world, it's all fair?
Well, that's a good means and ends question, but we live in a democracy where we vote every 5 years. The process is important to us. The means matter. Going to court and being able to ask for your rights defines us as citizens. So to say that the ends will justify the means, that's simply not correct. Because how those means ride roughshod over people's aspirations and ideas of themselves will eventually impact on the end in itself. Right? This is not just building a house, so I'll quickly get some kind of clearances, and I don't care how I get those clearances, my house is ready. That process of achieving that end will also define who we are as people. So the means and ends can't be so easily distinguished. In the case of the UCC, you're right, it's competitive discrimination that is in the fore of people. They say, yes, you can discriminate so much, but I can't discriminate, so your personal law is bad. Not because we want to genuinely improve the lot of women in our country. That's very far away from people's minds. Even the triple talaq case, a judgment which has to be lauded because it is an inhuman thing to say talaq to a woman 3 times and then throw her out. But when you read the judgment, there is no mention of sex discrimination on the basis why it's struck down. The court did not strike down triple talaq because a man can do it but a woman cannot. They struck it down that is abhorrent that anyone can can say talaq thrice and divorce their partner. So again, that was also blind to gender. So I think when the UCC comes in a time of our country today, when as it is, the minorities are feeling so vulnerable, and you, even if with the best of intentions, and I don't think you have the best of intentions, try to enact a UCC, you will alienate so many people. You will make the second-class citizens really feel that they are being further pushed. No one has a right to discriminate. But why is it that suddenly you've got the stock of UCC? And it's not as though I trust the framers of any political party, but particularly the majority one today, to come up with a UCC which is going to be truly fair. We only have to read the provisions of live-in relationships in Uttarakhand to realize that they're most likely going to make a mess of it. And if they're going to make a mess of it, I don't think we should allow them to do that.
My final question, Saurabh, is going to be that, people who, and there are enough number of people in this country who want to argue every now and then against reservations. They point to the fact that the reservations have not done their job. We are in a situation today where we're asking for more and more reservation for more and more communities. But as you very rightly pointed out, that is not a flaw in the idea of reservations. It's a flaw in the, I'm going to eat into some of your time, so bear with me. It's a flaw in the fact that we've been intellectually lazy in applying the spirit of the equality code, if not the letter. And we touched upon the fact that if we don't have enough jobs, if we are not investing in human development, if we are not investing in education, we spend abysmally. Our budget for healthcare and education is abysmal. We don't invest enough in infrastructure. Our criminal justice system, as you would know very well, is deeply, deeply flawed. I mean, who can go and register an FIR there are very few people who can walk into a police station and their FIR is going to be registered without being able to make certain calls. And also the fact that we are now increasingly moving towards a welfare state, which is looking at, you're moving away from a rights-based system to a sort of handout-based system. So we're looking at cash transfers, but we are not strengthening the sort of frameworks of education and so on, and health and so on. In this context, how should the spirit spirit of what the constitution makers wanted our equal society to look like, be thought of and imagined in the decades to come?
You know, nowadays in politics, it's very fashionable to talk of rights and duties. That, oh, you citizens all demand your rights, but what about your duties? And I would point out that our constitution is all about rights. And we as citizens are just not concerned enough about our rights. We take them so lightly. We brush away our rights. We give away, barter away the greatest of our rights for the smallest bit of progress. And in the process, our rights get whittled further and further and further till we wake up in one day and find out that we have none left. So the spirit of the Constitution, which has a chapter on fundamental rights, the chapter on fundamental duties only came later, but the Constitution embodies the idea that every citizen will only be able to live freely, fairly in a united India when they have all their rights. Rights are a means to adopt a constitutional promise and Article 39, which is of a common good, a richer India, an India which is prosperous and which we all grow. It's not as though rights stop you. This idea of living in a country where there's a totalitarian leader who will guide us benevolently towards a more prosperous future, that's never worked anywhere. You only have to look at the USSR or any other dictatorship to see that doesn't work. You need your rights. You need this cacophony of voices that we always had in India, the plurality, the diversity that we had, and the freedoms that are necessary to protect that plurality and diversity, to ensure that we can live in a country where everyone progresses. So just know your rights. You know, don't give up your rights. I mean, for a bit of money, don't sell your soul. In the name of public order, security, terrorism, don't give away these rights that we, our freedom fighters had to fight for. These are hard fought and they will be even more hard to retain. They're disappearing now as you speak. You don't even think about it, but fight for them.
Those are words to live by. I will now, I think, be able to take a couple of questions. Yes? 2 questions. That's just, okay. We'll take a bunch of questions together. Well, to the lady here.
Is this audible? Yes. Sir, I'm a huge fan of yours. First of all, I have heard your debate with Jay Sai Deepak and I was mesmerized after that. Before that, I was not knowing much about you.
An easy opponent.
Yeah, I know he was I like him too, though. Okay, so I have I have basically just 2 questions.
I'm sorry, you'll only get one because I'm allowed 2 questions.
Okay, I just have one question then. Does right to equality be in consonance with the rule of majority? Can we say this like the rule of majority is the right of equality?
Absolutely not, and neither should it be. Majorities will always do what is good for the majority. 51% can't be allowed to walk over the other 49%. Equality means everybody, however different they are, or in the case of queer people, we remember the judgment of 2013 when Justice Singhvi said, oh, you're a minuscule minority, you don't have your rights. No, our constitution protects the minority. A right to equality is about, as I said, celebrating difference, and therefore it is inherently counter-majoritarianism. And if we live in a democracy, we don't live in a majoritarianism. So yes, there are opposed potentially, and so be it.
Hello, Mr. Kirpal. Hello. My question is, you talked about constitutional morality, and you reflected on how the Constitution of India is a sui generis document, so to speak. Given this context, the courts, the constitutional courts of this country, their playing field is the Constitution. But do you find it problematic when the courts try to Sanskritize rights? Or, so to speak about Nalsa, Nalsa versus Union of India. Our rights were legitimized because there was some Brahminical sanitization to it. Do you find it problematic? Given the points that you just mentioned, that does the means become legitimate if the end is fostered too?
That's an important question and a very good one. Increasingly in Supreme Court judgments, we see the Gita being quoted as almost a canonical text. The only canonical text that exists for the court should be the Constitution of India. We lawyers are also guilty of it. I too have cited in the 377 case. You cite religious authority because you want to win a case, right? And you're appealing to human beings and you want to appeal to what they think. That's a lawyer's trick. That is no part of judging. Judgments are written for posterity, and they're written by the moral authority of the Supreme Court. And when the Constitution says it is colorblind when it comes to religion, no religious text has any place in a judgment.
I think we can take one more question.
How long do you think it will take for marital rape to be criminalized in India, considering the fact that a female minister herself says that it will threaten the institution of marriage and attack it or whatever?
That's, for one, I think the institution of marriage is ripe for being threatened, given how flawed it is. But I think that's an answer where the soothsayer will be able to give more readily than I. Obviously, Parliament is not going to act on it. The change will have to come from court. And it seems to have been put on a bit of a back burner. And it depends on some individual Chief Justice coming at some point in the future who thinks that the lives of women are important enough to rule on this. When that will happen, I can't say.
That's all we have time for. If you have more questions, you're going to have to buy the book, and Saurabh is going to be signing the book, so you'll have your opportunity to have a word with him. Thank you very much for being such a great audience. Thank you, Saurabh.